Okay, in this video I want to just take a look at a couple of aspects of negligence law in Ireland. We've seen, or I have made another video there, setting out the four basic components of a negligence action or negligence claim. And they are that if you're claiming off somebody, be it an employer or be it another person or be it a driver or be it a limited company, and you're claiming that they were negligent, then you need to show four elements. One, that they had a duty of care towards you. Two, that they failed to meet the required standard of care, assuming that they had a duty. Number three, that you've suffered loss or injury or damage as a result of that failure. And four, that there's a connection between their conduct and your loss. So they're the basic four elements of a negligence claim in Ireland, or indeed in any common law jurisdiction like the United Kingdom or United States. In this particular video though, I want to look at just two aspects of those four elements. One is the duty of care, in other words, who do we owe duty of care to? And secondly, what is the standard of care that's owed? So to whom do we owe duty of care? Well, the guiding principle in Ireland is one called the neighbour principle. You basically owe duty of care to those who are proximate or close to us and who are foreseeably likely to be damaged or injured by our actions. They don't have to be physically close to us, but they do need to be sufficiently close that our actions may cause them damage or loss. So, it's essentially the neighbour principle. In other words, if you're going to do something which is likely to cause somebody harm or damage, well then the likelihood is they are sufficiently proximate or close to you that you owe them a duty of care. So what are you liable for? What are we liable for? What is the scope of that duty? Essentially three things in Irish law: physical injury or damage, psychiatric injury or damage, and pure economic loss. The Irish courts have recognised that if you're held liable in negligence, then you can be held liable for any of these things, as I say, physical injury, psychiatric injury, or pure economic loss. So what is the standard of care? The standard of care is a nebulous enough sort of concept, but essentially it is the standard of behaviour that's expected from a reasonably careful person in the circumstances. So the reasonable man or woman, what would they do in the particular circumstances? That's essentially the standard of care. Now there will be allowances made for the particular physical characteristics of an individual in a court deciding what is the appropriate standard of care, but generally the standard of care is what is expected from a reasonably careful person. There are four factors then that the courts will look at in assessing negligence. One is the probability of an accident. Two is the seriousness of the threatened injury. Three is the social utility of the defendant's conduct. And four, the cost of eliminating any risk associated with it. Let's take a look at the probability of an accident. Essentially, the more likely an accident, the more likely there will be negligence. The reverse is also true. In other words, if it's completely unlikely or completely freakish that there would be an accident, then it's less likely that there would be negligence. In other words, it could be a one-off sort of a situation which is entirely unpredictable, entirely unforeseeable. The second factor in looking at assessing negligence is the seriousness of the threatened injury. If the seriousness of injury is great or significant, then even a slight risk may be held to be negligent. The third factor you'd be looking at, or a court might look at in assessing negligence, is the social utility of the defendant's conduct. If the activity has a high social utility, then greater latitude will be afforded to the defendant. Social utility has to do with, for example, maybe a Boy Scout leader bringing children on a trip or something of that nature. Clearly there is great social utility in that and in any contribution towards society generally. So a person in that situation will be afforded a slightly greater degree of latitude. And finally, the fourth factor that a court will look at will be the cost of eliminating the risk. A slight risk may be reasonable if the cost of eliminating it is completely excessive. So, that is just a cost-benefit analysis that's essentially carried out. some risks are so small and so negligible that there isn't any huge point in trying to spend or committing to spend a lot of money in trying to eliminate that slight risk. My name is Terry Gorry. I'm a solicitor in Enfield. My contact details are on the screen there. If you find this video useful, please give us a thumbs up down below, and you can subscribe to my YouTube channel if you wish. I have a lot of information on it about various aspects of law in Ireland, all sorts of law: employment, business, family, criminal, road traffic, negligence, personal injury claims, and so on.